it's attorney Alexis Hart McDowell here, your Enterprise Esquire, handling all of your business formation, corporate, nonprofit, and real estate needs. Today, I'm coming to speak to you about the breaking news alert that I put on Instagram regarding Cook County Recorder of Deeds suspension from accepting affidavits of heirship and deeds from heirs to transfer property when the owner of that property has died. So, a deceased owner. Instead, the county is now requiring that any heirs be legally declared. That's the correct legal term. They have to be legally declared heirs, which means that they now have to go through a portion of the probate process and be declared the heirs by a judge with a court order. So, just to give you a little background, when you own a piece of property and you don't have a will and there you own the property by yourself, when you pass away or when you die, that property would go to your heirs. So historically, or up until this point, an heir could say, hey, it's just me and my brother. My father and my mother passed away. We're the last two. And under the intestate laws of Illinois, we're entitled to the property. Since your name wasn't on the deed, you would have to complete an affidavit of heirship and a new deed, and you could record that, and it was accepted by the Cook County Recorder of Deeds. They are now saying that that is no longer possible. It was a quick and easy way to avoid probate and for the heirs to get title to the property so that they could do what they needed to do, whether that be mortgage the property or sell it or whatever they needed to do legally. Now that has gone away. They are no longer accepting that from heirs. The heirs will have to go through a partial probate process and be legally declared the heirs of the property. That process takes approximately 2 weeks. That's what they're saying, and costs around $193 in filing fees. That doesn't include attorney's fees or anything else if you're seeking an attorney to help you with the process. So it doesn't complicate you getting title to your deed if you're an heir, but it does elongate that process. It does lengthen that process for you. I want to go over a couple of ways to transfer property outside of the probate process, because that's what I get a lot of questions on. People don't have time, they don't have money for probate, for the attorneys, bonding, whatever is required with the probate process. So, in order to set your family up and to protect your family, here are a couple of ways that you can transfer property without going through probate. So the first way is to have a deed held in joint tenancy. So if you're the owner, if you're the mom, the dad, whatever, put your child's name or whoever you want to own that property when you pass away. It doesn't have to be your child or spouse or whoever you want to own that property when you pass away. Put their name on the deed, and you need that legal language that says they own it in joint tenancy with a right of survivorship. Okay. And then when you or the other person passes away, whichever one happens first, the other person will own that property outright. They don't need to do anything. They don't have to go to probate. They don't have to file any papers. It's already recorded and it automatically transfers to that person. It also happens with spouses. It's called tenancy by the entirety. So it would be husband and wife and husband, whatever, civil unions. And it's a tenants by the entirety. Okay, that's for a married couple. The other way to transfer property outside of probate is through using a living trust. You can create a trust document, and the deed is held in trust, and it is transferred to the beneficiaries upon your death, and that does not require probate. It's a contractual agreement, and once you pass away, the trustee is able to record a trustee's deed with the names of the new beneficiaries. Lastly, Cook County still has a process called transfer on death instrument, and it's essentially a piece of paper. This is what it looks like. It's on the Cook County website. Transfer on death instrument. You complete this form, you designate who you want to receive the property upon your death, It has the same requirements as a will. You have to have two disinterested witnesses sign, and it has to be notarized as well. And then you take this form and you can record it with Cook County Recorder of Deeds. Okay. Now, upon your death, the heir who you listed on that form is going to have to give a notice of death, notice of affidavit of death saying that, hey, you died, and a new deed where it's transferred, to them. And then they record that, and that's all outside of the probate process. So those are just three ways to transfer property outside of the probate process to kind of help your family financially, to avoid disputes, family fights, things like that. I have this all the time, especially in blended families. If the mom or the dad got remarried and you want the house to go to your kids, if you don't do that, it's your spouse is entitled to the house, and then your kids are thinking that they're getting the house. So it's it helps avoid a lot of the messiness. So just to recap, it's very good to try and, as part of your estate planning, to set up who you want your real estate property to go to. There's several ways that I just discussed that you can transfer property outside of probate, including a deed held in joint tenancy with the right of survivorship, or tenants by the entirety if you're married. Number two, have a living trust. Or number three, the transfer on death instrument, which form can be found on the Cook County Recorder of Deeds website. All three of those ways will help your family retain ownership of the property without having to go through the probate process. So I hope that this information helps. If you have any questions, feel free to reach out. Go to enterpriseesquire.com /calendar. You can always book a free 15-minute appointment. My calendar is always up to date. I look forward to helping you and your family with their real estate needs. Thank you and have a great one.